Hello everyone, my name is Aaron Woodman, and I want to welcome you to my YouTube channel. In this video, we are going to talk about your right to use social media as a public forum. Let's go through the background information. On April 27th, 2010, Lester Gerard Packingham was thrilled to have beaten a traffic ticket. And so he did what many of us do to share our good fortune. He went to Facebook to post about it. Unfortunately for Packingham, around the same time, Officer Brian Cheney of the Durham Police Department was investigating registered sex offenders who were violating a North Carolina law that prohibited them from accessing social media. Officer Cheney saw the traffic ticket statement on Facebook, posted by someone named J.R. Gerard. Looking at the profile photo, Shaneen thought he recognized the man as a sex offender. So he tracked down the court records of traffic tickets dismissed around the time of the post and came up with Packingham's name. Shaneen followed up by obtaining a search warrant for Packingham's home, which turned up the evidence needed to confirm that Packingham had been using Facebook under the alias J.R. Gerard. A year later, Packingham was tried for violating North Carolina law, Section 14-202.5, which made it a crime for a registered sex offender, quote, to access a commercial social networking website where the sex offender knows that the site permits minor children to become members or to create or maintain personal web pages, unquote. The purpose of the law was to prevent sex offenders from gathering information about children in order, quote, to target an unwitting victim under the guise of familiarity or shared interests, unquote. Since 2008, the law had applied to about 20,000 North Carolinians, and more than 1,000 people had been prosecuted for violating it. At trial, the basics for Packingham being on the sex offenders registry was presented to the jury. 9 years before, when Packingham was 21 years old, quote, he had sex with a 13-year-old girl, unquote, and pleaded guilty to, quote, taking indecent liberties with a child, unquote. Packingham was on supervised probation for 2 years, and had not had any problems with the law since his conviction. Prosecutors did not claim that he had contacted a minor or committed any other illegal acts on the internet. Packingham was found guilty and sentenced up to 8 months of imprisonment, but any jail time was suspended and he was placed on supervised probation. On appeal, the law was struck down for violating the First Amendment. The Court of Appeals of North Carolina held the law unnecessarily prevented, quote, a wide range of communication and expressive activity unrelated to achieving, unquote, the state's legitimate interests in protecting children from sex offenders. The North Carolina Supreme Court disagreed and ruled 4-2 that the law was, quote, constitutional in all respects, unquote, and, quote, carefully tailored, unquote. North Carolina's highest court also found that the law provided access to websites that served as sufficient alternatives to social media, giving Paula Deen Network and a local NBC station as examples. An appeal would go to the Supreme Court, and they would grant the review. This case was called Packingham v. North Carolina. At first, it was unclear how eager the justices would be to directly engage with the social media aspects of the case. However, at oral arguments in 2017, their questioning quickly made clear that the nature of social media was central to their views about speech limits. Let's talk more about this case. Chief Justice John Roberts expressed dissatisfaction with the lack of precedent regarding the First Amendment and social media. He said, quote, we don't have a lot of history here concerning access to websites and all sorts of things we're dealing with here, unquote, in which he referred in part to the, quote, broad access to minors, unquote, that the internet provides. Packingham's lawyer, David Goldberg, agreed that, quote, as with any matter of new technologies the court has confronted, there isn't a framing or reconstruction era analog, unquote. However, he pointed out that, quote, when you talk about all the things that the state historically has restricted, they never said you lose your right to publish a newspaper because you've been convicted, unquote, of a crime. Regardless of the technology, Goldberg contended the wide-ranging post-prison speech restrictions of the North Carolina law was still historically unprecedented. Expressing concern about the safety of children, Justice Ruth Bader Ginsburg wanted to know, quote, suppose a law simply said that someone who was a sex offender could not communicate with a minor on social media. Would you agree that that would be constitutional, unquote? Goldberg initially hesitated, but then agreed that it probably would be. Goldberg's reluctance seemed misplaced, as if he didn't recognize that accepting the limitation presented by Ginsburg would support his case. If there was a less speech-restrictive alternative available to North Carolina that still served the state's goal of protecting children, then the court would likely find the current law to be overbroad and too restrictive. Robert C. Montgomery, Senior Deputy Attorney General of North Carolina, spoke for less than a minute before being interrupted by Justice Elena Kagan. She said, quote, so a person in this situation, for example, cannot go onto the president's Twitter account to find out what the president is saying today. Not only the president, we're sort of aware of it because the president now uses Twitter, but in fact, everybody uses Twitter. All 50 governors, all 100 senators, every member of the House has a Twitter account. So this has become a crucially important channel of political communication, and a person can go onto those sites and find out what these members of our government are thinking or saying or doing. Is that right? Unquote. Montgomery had no choice but to answer, quote, that's right. However, there are alternatives. Usually those congressmen also have their own web pages, unquote. Justice Anthony Kennedy built on Kagan's comments by saying, quote, well, it seems to me, assuming we had a public square 100 years ago, could you say that this person couldn't go into the public square? The sites that Justice Kagan had described and their utility are greater than the communication you could have ever had, even in the paradigm of public space, unquote. Justice Kennedy's focus here on public squares is referring to the idea that in public squares, sometimes called public forums by the Supreme Court, where people can freely gather and talk, freedom of speech should receive the highest level of First Amendment protection. In response, Montgomery accepted the metaphor, but argued that quote, in essence, states have said that sex offenders can't go into public squares, that they can't go into parks, or they can't go near playgrounds, unquote. Justice Kagan said, quote, 50 million Americans use social media for religious community purposes. So whether it's a political community, whether it's a religious community, these sites have become embedded in our culture as ways to communicate and ways to exercise our constitutional rights, haven't they? Unquote. Montgomery tried hard to maintain that, quote, there are other alternatives still. This is a part of the internet, but it's not the entire internet that is being taken away from these offenders. They could still have their own blog. They can read blogs. They could do podcasts. They could go to nytimes.com. They could do other things to communicate with people, unquote. Justice Ginsburg said, quote, these people are being cut off from a very large part of the marketplace of ideas. And the First Amendment includes not only the right to speak, but the right to receive information, unquote. Montgomery could do little other than acknowledge this. Justice Samuel Alito challenged the idea of social media as vital to contemporary life and pushed back during Goldberg's final minutes of rebuttal. He said, quote, now, I know there are people who think that life is not possible without Twitter and Facebook and these things, and that 2003 was the dark ages, unquote. With all these arguments in mind, the Supreme Court unanimously voted in favor of Packingham. Justice Kennedy wrote the opinion of the Supreme Court. He said, quote, a fundamental principle of the First Amendment is that all persons have access to places where they can speak and listen, and then, after reflection, speak and listen once more. The court has sought to protect the right to speak in this spatial context. A basic rule, for example, is that a street or a park is a quintessential form for the exercise of First Amendment rights. Even in the modern era, these places are still essential venues for public gatherings to celebrate some views, to protest others, or simply to learn and inquire. While in the past there may have been difficulty in identifying the most important places in a spatial sense for the exchange of views, today the answer is clear. It is cyberspace, the vast democratic forms of internet in general, and social media in particular. While we now may not be coming to the realization that the cyber age is a revolution of historic proportions, we cannot yet appreciate its full dimensions and vast potential to alter how we think, express ourselves, and define who we want to be. As a result, the court must exercise extreme caution before suggesting that the First Amendment provides secant protection for access to vast networks in that medium, unquote. Turning to evaluate the North Carolina statute, Kennedy recognized the significant interest of protecting, quote, the children and other victims of sexual assault from abuse, unquote. However, quote, the law must not burden substantially more speech than is necessary to further the government's legitimate interests, unquote. Kennedy notes that states could constitutionally, quote, enact specific, narrowly tailored laws that prohibit a sex offender from engaging in conduct that often presages a sexual crime, like contacting a minor or using a website to gather information about a minor. Yet that was not what had occurred here. To the contrary, the court found the statute at issue was unprecedented in the scope of First Amendment speech it burdens. By prohibiting sex offenders from using those websites, North Carolina, with one broad stroke, bars access to what, for many, are the principal sources for knowing current events, checking ads for employment, speaking and listening in the modern public square, and otherwise exploring the vast realms of human thought and knowledge. These websites can provide perhaps the most powerful mechanisms available to a private citizen to make his or her voice heard. They allow a person with an internet connection to become a town crier with a voice that resonates farther than it could from any soapbox. And some to foreclose access to social media altogether is to prevent the user from engaging in the legitimate exercise of First Amendment rights, unquote. Therefore, the Supreme Court agreed that there was no choice but that the, quote, law must be held invalid, unquote. Still, there was disagreement as to the scope of the opinion. Justice Alito wrote a concurring opinion joined by Chief Justice Roberts and Justice Thomas that took Kennedy to task because they believed he had gone too far, troubled by what he called, quote, the implications of the court's unnecessary rhetoric, unquote. Alito scolded the other justices for being, quote, unable to resist musings that seemed to equate the entirety of the internet with public streets and parks, unquote. He feared that states would consequently be, quote, largely powerless to restrict even the most dangerous sexual predators from visiting any internet sites, including, for example, teenage dating sites and sites designed to permit minors to discuss personal problems with their peers. The court is correct that we should be cautious in applying our free speech precedents to the internet. Cyberspace is different from the physical world. We should proceed circumspectly, taking one step at a time. It is regrettable that the court has not heeded its own admonition of caution, unquote. So we now know that this ruling recognized the internet and social media as public forums for exercising First Amendment rights to free speech and assembly. Broad bans on social media access for registered sex offenders are unconstitutional because they prevent legitimate, lawful speech and activities such as reading a news article or saying congratulations to someone on an accomplishment they made. States can still pass laws to prevent specific harmful actions such as using social media to solicit a minor or to conceal their identity. However, a law that bans access to a wide range of sites, regardless of the user's conduct, is unconstitutional. Still, the most important thing for everyone is that we can treat the online space as a public forum to share any information and thoughts we have for society to see. At the same time, though, this opens the door for people to say bad things online. Let's look at an example of someone pointing this out. Sacha Baron Cohen, the comedian and actor famous for pranking people on camera as Borat and other fictional characters, walked into the Anti-Defamation League's 2019 summit, and it was no joke. In a scathing speech, he blamed surging hate crimes around the globe on, quote, a handful of internet companies that amount to the greatest propaganda machine in history, unquote. Cohen warned that, quote, our pluralistic democracies are on a precipice, and the role of social media could be determinant, unquote. Pointing the finger at the group he dubbed the Silicon Six, the billionaire leaders of Facebook, Google, YouTube, and Twitter, he called for, quote, a fundamental rethink of social media and how it spreads hate, conspiracies, and lies, unquote. He said, quote, last month, however, Mark Zuckerberg of Facebook delivered a major speech that, not surprisingly, warned against new laws and regulations on companies like this. Zuckerberg tried to portray this whole issue as choices around free expression. That is ludicrous. This is not about limiting anyone's free speech. This is about giving people, including some of the most reprehensible people on Earth, the biggest platform in history to reach a third of the planet. Freedom of speech is not freedom of reach, unquote. Hate speech and personal attacks by online trolls are, of course, just part of the problems plaguing social media. As the United Nations Special Rapporteur on the Promotion and Protection of the Right to Freedom of Opinion and Expression has observed, quote, hatred is spreading through online platforms with the help of manufactured amplification. Incitement to violence and discrimination seem to flow through their veins, and they have become highly successful and profitable zones for disinformation, election interference, and propaganda, unquote. As you can tell, these are problems that need to be addressed, but according to the Packingham case, it does not tell us what can be done to mitigate the problems created by social media, trolls, and hate mobs. It just establishes that the internet and social media sites are considered public forums. Remember, all social media platforms are private entities and so do not have to abide by the First Amendment. They can abridge the freedom of speech all they want. They can kick people off their platform, restrict speech based on its message, or refuse to accept ads from whomever they choose. These choices represent editorial decisions that reflect the free speech rights of the social media companies themselves. While this raises a host of political and social issues, the courts won't find these to be violations of the First Amendment. Also, social media platforms are immune by federal statute for anything their users post, thanks to Section 230 of the Communications Decency Act, enacted in 1996. The Electronic Frontier Foundation and leading digital rights advocacy organization has described Section 230 as, quote, the most important law protecting internet speech, unquote, arguing that this relatively obscure provision has enabled, quote, the kind of innovation that has allowed the internet to thrive, unquote. As a result, without foreseeable legal pressure from either lawsuits or constitutional challenges, any major social media reforms will most likely come from somewhere other than the courts. Packingham, at its core, shows that all of the participating justices are unwilling to allow the government to place blanket restrictions on social media. Packingham also highlights the threshold questions. How should social media be treated as unexceptional and receive the same stringent defenses according to speech in general? Or is social media so different that it should be treated as exceptional, a type of speech that could be more directly regulated in ways the press is not? Kennedy's opinion, with its embrace of past metaphors, sees social media as unexceptional, whereas Alito maintains that the internet is so exceptional in ways that pose greater dangers and therefore may require more intrusive speech regulations. So with all the contemporary social media challenges we are facing now and will soon face, it remains essential to understand the free speech rights that the Supreme Court has established. This is so we know what we can say and not say in the spaces we enter. The future of free speech is certainly online. How we as Americans seek to build a future can only begin by taking in and learning from our First Amendment cases of the past, so we can use them as guidance for our free speech rights. In the next video, we will provide a recap of this video set series on the interpretations of free speech rights. Until then, please like this video, subscribe to my YouTube channel, and turn on the post notifications so you will be notified when I post my next video. I appreciate your support. Remember, you are powerful, you are capable, and you are the changemaker our society needs. Thank you so much for watching this video. I will see you soon.